In California estate litigation, some of the most emotionally charged and legally complex battles arise when a family disagrees over what belongs to whom. Was that house shared by both spouses, or was it inherited before the marriage? Is that investment account separate property or part of the marital estate? At Hackard Law, we represent clients across California in trust and estate disputes, and we know this. When the line between community and separate property isn't clear, the conflict can be devastating. Let's talk about why these disputes happen and how California law defines what's mine and what's ours after someone passes away. Segment 1. Understanding the basics. California is a community property state. That means any income or assets acquired during the marriage by either spouse are generally considered community property. Separate property, on the other hand, includes anything you owned before marriage, as well as gifts or inheritances received during marriage, as long as you've kept it separate. That sounds simple, but real life isn't. Over time, accounts are mixed, titles are shared, property is improved with marital funds, and intentions go undocumented. When one spouse passes away, the trust becomes active, and suddenly the children from a prior marriage or the surviving spouse may disagree on what's included. Segment 2, how disputes arise in trust. We see this all the time. Here are some of the most common scenarios. A trust favors the decedent's children, and the surviving spouse feels shortchanged. A home purchased during the marriage is titled in just one name. Is it community or separate? A spouse amends the trust late in life, changing asset distributions, sometimes without the other's knowledge. Assets meant to go into the trust were never titled properly. Now, no one knows who owns what. Each of these situations opens the door to conflict, especially when grief, blended families, and high-value assets are involved. Segment 3, why titling and documentation matter. When it comes to proving what's community and what's separate, the key is often in the documents, or the lack of them. Did the couple sign a transmutation agreement? Was the property refinanced in both names? Were separate funds used to buy joint assets? Courts look closely at how the property was titled, treated, and documented over time. And when the paper trail is missing, they'll rely on testimony, patterns of behavior, and expert analysis. That's where strategy, experience, and good storytelling matter. Segment 4, the role of the surviving spouse and adult children. Some of the hardest cases we see involve a surviving spouse and adult children from a prior relationship. Both sides often feel entitled. The spouse believes they built the estate together. The children believe they're being cut out of their parents' legacy. And when the trust is vague or amended late in life, emotions escalate. We understand how personal these conflicts are. They're not just legal, they're deeply human. Our job is to bring clarity to the law, strength to your case, and compassion to a painful chapter. At Hackard Law, we represent both spouses and beneficiaries in these community versus separate property disputes. We know California law. We know how the courts interpret these issues. And we know how to uncover the facts that can make or break your case. If you're facing a dispute over a California trust, contact us at Hackard Law. We're here to protect what matters to you and to the people you love.